everybody. I hope you can hear me. My name's Gemma Taylor. I am Silk, senior member of 42 Bedford Row, and I'd like to welcome you this evening to our latest webinar, which is called, it is in fact going to be a discussion about the vulnerability, fairness and the remote family court. We have two fantastic panelists who are Siân Smith, barrister at 42 Bedford Row, who many of you will recognise because she often introduces our talks. She is the chair of the FLBA Vulnerable Witness Working Group, and she's been instrumental in designing the training course for family practitioners in the cross-examination of vulnerable witnesses, which is just getting off the ground. Some of you may have completed part of that training. This training includes, and Siân has prepared comprehensive practice materials, and in fact there's nothing that Siân doesn't know about the law, good practice and procedure with respect to vulnerable witnesses. Siân is going to be very ably matched by our guest, Nicola Lewis, who is a registered intermediary and communication specialist. Nicola has been an intermediary since 2014, and as we know what intermediaries do, she assists children and vulnerable adults with mild, moderate learning difficulties. She is also a trustee for the Intermediaries for Justice and has been heavily involved not just in the FLBA training programme, but also training for criminal advocacy, and she trains intermediaries for justice. We are going to, I'm going to pass you over in a moment to Siân and Nicola, and they're going to share their experience and give advice about how to achieve fairness, and particularly for vulnerable parties and witnesses in remote and hybrid hearings. There will be time at the end of their discussion to have questions, and it would be really great if during the talk, if you're so inclined, if you could just send in your questions on the QA app, and we'll try and fit in as many as we can at the end of the talk. So without further ado, I hand over to Siân and Nicola.
Good afternoon, everyone. So this evening, Nicola and I are going to be talking about vulnerability in the remote family court. Remote hearings have been vital to the continued functioning of the family justice system in the pandemic. But as we all know, they can pose particular challenges in terms of vulnerable people who are accessing the courts. I've put in the chat, or I'm about to put in the chat, a link to our website where you'll find what I've called a vulnerable persons checklist, which sets out a bit of a guide or format for thinking about meeting the needs of vulnerable people who come before the courts. And it includes a bit of a pre-proceedings section, which is aimed at various professionals, including social workers, but as well as lawyers. So during the pandemic, the Nuffield Family Justice Observatory have published 2 reports in respect of remote hearings. A rapid consultation took place in April, and then they did a follow-up in October. I highly recommend reading those reports. They've got a lot of direct quotes from those who responded to them, a range of people, lawyers, judges, but including court users, and gives a real insight into the experiences of those coming before the remote courts. The guidance given by the Family Justice Observatory has also been specifically endorsed by the President, and so we should be paying close attention to that. As we know, the Family Procedure Rules 3A and the Practice Direction 3AA give us the procedural regime for considering the participation of vulnerable parties and witnesses. Central to that are the duties placed upon the court and the advocates to identify any party or witness who is vulnerable, and to work with the court to ensure that they can participate without the quality of their evidence being diminished and without being put in fear or distress by reason of their vulnerability. So in order to discharge our duties, we really need to understand the challenges posed by remote hearings and to give proper thought to what can be done to ensure that vulnerable parties and witnesses are not put at a disadvantage by remote hearings. Now, of course, every individual is different, and we encounter a range of vulnerabilities in the family court, including learning disabilities, mental health difficulties, vulnerabilities caused by domestic abuse and trauma, neurodevelopmental conditions, social communication difficulties, language barriers, deafness, and many physical disabilities, all of which require their own particular consideration. So I'm going to start our discussion by asking Nicola to help us consider what are the different challenges posed by remote hearings for people with vulnerabilities, and what issues do we need to have uppermost in our minds in respect of the wide range of needs that we come across with those accessing the family courts. You're on mute, Nicola.
Phew. Hi, thanks very much for inviting me to join you today. I think the key point really is, as you said, everyone is different. So every vulnerable person that we're meeting in the family court will have bespoke needs. But I think what we've identified is that planning is really key in remote hearings and any kind of remote interaction with vulnerable people. And hopefully, if you've got an intermediary on board, the intermediary will have outlined in their report what the issues are and what the particular challenges are facing that vulnerable person. So, for example, the different challenges will depend on the setup that you have. It may be a telephone hearing, it may be a fully remote hearing, it may be hybrid with a vulnerable person remote from the intermediary, or the vulnerable person with the intermediary somewhere, or the vulnerable person and the intermediary in court. And each setup will require a bespoke answer really as to what we should be looking for and what the challenges might be for that specific person. So one difficulty is if the intermediary is not with a vulnerable person, are they able to work with two channels of information? So are they able to listen and participate in what's going on in the court whilst listening in another way to the intermediary, particularly if they're remote and they're trying to stay in touch using telephone or WhatsApp or FaceTime? I think it's worth saying as well, the other challenges really is the mental health issues and the impacts there on the remote participation. I mean, in COVID, there's issues about whether or not people want to travel to court. There's also people have difficulties with focus and concentration, quite often, vulnerable adults and children. And how you set up the hearing for them and where and how they participate will involve thoughts about those issues as well.
Thank you, Nicola, and we'll try and explore some of those issues in detail as we go along. At the outset, a key issue for lawyers, and I suppose judges as well, is the identification of a party's needs as early as possible. In some cases, of course, we'll have those vulnerabilities identified for us in the papers, but that isn't always the case. And I'd like to just think about what issues does remote consultation with clients pose in terms of identifying vulnerability, and what, if anything, can we do to improve the process to ensure we're not missing anything when we speak to our clients?
Well, it's incredibly difficult because you lose so much in remote communication that you have access to when you're in a room with someone. Again, like I said last time, everyone is different. So you may have some people who manage remote communication really well, and yet when you go to meet them face to face, you'll realize that something is not quite as it should be in terms of communication. With other people, you may be in a remote contact situation with them and it'll be very evident. You may be able to visually see that somebody is sweating or that they can't, focus, and that it causes them real difficulty, for example, to be on a meeting like this. For some people, it's actually an advantage. Some people with mental health issues may feel safer talking in a boundaried environment like this. But in terms of how you can really identify vulnerabilities, it's a tough one. It is a tough one. And it's why, as an intermediary, if I am forced to do a remote assessment for any reason, I always say that I need to do a follow-up face-to-face meeting just to see how much of the difficulties may have been caused by the remote medium itself and how much may rest with the person, even in a face-to-face context.
Thank you. I just want to touch, if I may, on some recent case law. It's a case of RES, vulnerable parents intermediary, a case of last year. I can put the citation in the chat box in a moment. But the Court of Appeal in that case dealt with an appeal in which a mother with a learning disability had been refused an intermediary assessment at first instance. And in overturning that decision, Lord Justice Peter Jackson gave the judgment of the court, considered an interim report that was in use in the criminal justice system, which found that video hearings can significantly impede communication and understanding for disabled people with certain impairments, and gives the examples of learning disability, autism spectrum disorders, and mental health conditions. And the Court of Appeal made clear that the decision in the family court as to whether to make a particular participation direction, in this case, it was whether to direct an intermediary, required really two things. One, a focus on the type of hearing. So in that case, it was a hybrid hearing with the two streams of communication you were talking about. And where the party would be cross-examined by counsel on a screen, so removing some of the visual cues, but also a consideration of the likely experience of the vulnerable person, including the potential outcome. Again, in that case, that her baby would be removed from her care. So his conclusion was that she should have had the support of an intermediary in this case. But it really highlights, I think, how necessary it is to consider the limitations and the implications of the different platforms that we have available, and what measures may be required to promote fairness. So I'll start with, I think, a platform that we all would think is the least satisfactory form of remote hearings, and that's telephone hearings. I'd include in that hearings where the party has to phone in, and so although everyone else can see and hear each other, they can't. I think they remain reasonably commonly in use, although practice may vary by area. But what particular issues should we have in mind, Nicola, in your view, when considering telephone hearings, and whether they are helpful or unhelpful to parties with vulnerabilities?
Well, I think my answer to that kind of depends on whether or not you've got an intermediary sitting with the vulnerable person. My first experiences of the telephone hearing, like you say, were very much expecting a video hearing to take place and suddenly getting that link and realizing we're all on the phone. And my problem, if I'm not working with the vulnerable person in the same place, is I can't see what's happening to them. So, for example, if people have mental health issues, I wouldn't be able to see if they were having a meltdown. If I'm working with somebody who's got learning disability, I wouldn't be able to see from their body language how much they were able to take in or how difficult they were finding the hearing. So if I can sit with the person in the same location as them, even if it's a telephone hearing, it's possible to put the hearing on mute and for me just to sit there and simplify and work with the person in the way that they need to be worked with. My experience otherwise, if the vulnerable person is in one place and the intermediary is in another, is the vulnerable person often says it's been really difficult, the hearing. They feel very detached. The environment is very formal. It all seems very distant and very impersonal. And they quite often feel very uninvolved. They're just there, but they don't even know if they're meant to speak or say anything or what their role is. And even worse, if they press that unmute button and they start chiming in when they shouldn't, it causes difficulties for everyone. So goes back to planning again, I think. And I think before we talked about this, the amount of planning that could go on between the advocate and the intermediary before they enter the telephone hearing to help explain to somebody what's going to be coming up, what their role is in the hearing, what they're expected to do and not expected to do, and then to debrief afterwards. The kind of technical difficulties that people experience on a phone hearing is you go in and the judge reads that bit out. And if the vulnerable person is on their own and they have no support, they've got no idea really what's going on there. And then all the advocates introduce themselves in a stream, Miss So-and-so for such and such. And that's very difficult too. So with the right planning, the intermediary and the advocate could possibly discuss it in advance, or the intermediary could send a note into the court saying, would it be possible to say, this is Gemma, who's representing mother, and this is so and so who's representing Stephen. And then the vulnerable person from the outset has got a good chance of knowing who's who, and at least who's saying what for whom.
Thank you. And I think we can think about that in our own practices in cases where intermediaries aren't appointed, that planning can go in any event and help protect participation for more vulnerable clients as well. And that's extremely helpful. Let's turn then to video hearings. So fully remote video hearings, I'm thinking here, rather than the hybrid. Generally thought to be an improvement on telephone hearings, but what particular issues should we be thinking about here? One particular sort of sub-question, I suppose, Nicola, for further discussion is when do limitations in respect of body language become significant? Is it primarily when a party is giving evidence, or is it in other hearings and at other times as well?
Yeah, so for remote hearings, online video hearings, the very obvious things are, and I should have mentioned this about telephone hearings as well, some people with vulnerabilities rely on face-to-face communication because the bits that they can't understand, if they've got a learning disability, for example, they can quite often work out using visual signifiers. So on the telephone, that's all lost to them, and they can feel really quite at sea. In a video hearing, you've got a certain amount of access to somebody's non-verbal communication and their facial expression, but it's very limited. And the difficulty with the video hearing is you're there. I'm sure we've all partaken in those CVP or those Teams meetings where you've got lots of different faces on the screen, and each time somebody comes and goes, the faces all move around, and then each time somebody's shut out of a CVP meeting, there's that knock, which is very distracting for a lot of people. There are ways of pinning the main people who are talking so that faces don't move around when people come and go. And if you've got a good usher and they can help you with that, they know how to use the CVP, if that's the system, then that can be really helpful. Also, some vulnerable people particularly with mental health difficulties, they don't like to be sitting there looking at themselves. An experience which I'm sure we've all shared as well. But that idea of having to sit in a hearing looking at yourself for very long periods of time can be incredibly difficult. So again, pre-planning, speaking possibly to the advocate about the possibilities of when the camera can be switched off or when it needs to be on. And of course, parents in contested hearings, they may have difficulties with one of the other parties. Could be the social worker, could be another parent. And so would it be possible for that person's camera to be switched off? Or if not, as an intermediary, sometimes I'll just stick a post-it over their face. But of course, if they're moving around on the screen, my post-it is having to fly around on the screen as well. So it's the visual aspect of it. Also, people with, say, for example, neurodevelopmental issues like autism, the whole sensory loss is very difficult for them to be able to deal with. Again, if they've got an intermediary in the space with them, they can help to regulate and manage that. But people on their own can find it really, really difficult to have lost all those things that we just take for granted, the rapport, the connection, the fact that you might turn around and look at someone and say, are you okay? And instead, all they can see is a row of fairly blank faces, or that circle with the white, white line through it, which again, can be very, very difficult for people who are used to having real contact and seeing people face to face.
Thank you. And interested to know the role for you as an intermediary in fully remote hearings. How does that work? Are you able to operate effectively if you're not in the same room as a client, or does that really make it impossible?
Again, it depends on the person. I mean, I've had very limited clients where I could say I would be okay to support them remotely. Very few people who I work with don't have the ability to use that separate channel of communication. So I have had a hearing where a mother's been in court, and when I had to isolate, I had to contact her via FaceTime, and she had the phone propped up in front of her, and she had an earpiece in. But actually, we worked out very quickly she couldn't manage two streams of information. So we just had to debrief afterwards and really explain what was going on there. So to be honest, it's not ideal, and to my mind, it doesn't work very well with many categories of vulnerability.
No, and here's probably a good point to mention that we understand some new functionality is coming on CVP. Nicola, I think you know a bit about that, certainly more than I do.
Well, we're trialling it. Intermediaries for Justice are trialling it with the MOJ on Monday, and they've set out a breakout room which intermediaries or interpreters can be in with the vulnerable person, and they can still hear the court hearing going ahead. So it should really be incredibly useful to have that separate breakout space and to be able to have that one-to-one connection. The only slight difficulty is I think the intermediary remains on mute throughout, and so to catch the attention of the judge might be difficult at times, but I'm really looking forward to trying it out.
Yes, you'll have to get a sign to hold up for the judge, Nicola. But I guess that will be used for interpreters as well, as I understand it. Which would be great. Thinking about communication pre-hearing between advocates and the clients. Now, I have thought a lot about this, and I think it's quite common for those conferences to take place by phone. But based on what you're telling us, Nicola, it seems like that's really the least effective option in terms of a party feeling connected to what's going on and to their lawyer and feeling that they're understood and understanding what is going on. Would you say that we should be making the effort to try and have pre-hearing conferences by video means?
Yeah, I think it might be a matter of possibly instructing solicitors to check that out a bit, because some people function very well on the phone, but they would rather not be looking at themselves for a bit longer. Some people would prefer to have that face-to-face communication. As an intermediary, it's part of my assessment, so it should be in an intermediary report if you have one on the case. But yeah, it's a matter of trying to balance that Zoom fatigue against having a face-to-face connection with someone. And I've had lots of experiences where barristers have said, look, you know, we've been in this hearing for 4 hours. The last thing you want to do is sit and talk with me again. I've often wondered whether it would be possible to front load that piece of work and have that short meeting the next morning or something, or not directly afterwards. But again, I don't fully understand the logistics there. So it really depends on how the person is managing, whether their focus is lost for the day, and whether that conversation can take place on either medium. I think we all recognise that, well, the understanding is that Zoom or remote hearings are far more cognitively tiring, and people struggle. People struggle with having the meetings before and afterwards, and the court attendance in the middle.
Thank you. And it brings me on really to the next topic, which is about breaks. So we know they're important, and we've been told that in the guidance we should be making sure that we have breaks to take instructions. But as you pointed out, we can't turn around and talk to our clients in court and ask them how they are, or give them a sort of reassuring nod. And we can't really hope to replicate that, I don't think, in a remote environment. And I just wonder if we need to try to do that, or the risk of overloading a client is too great there to keep setting up video conferences and telephone calls, and they need to be more planned. I suppose I'm asking really, Nicola, what should be the purpose of the regular breaks that we're taking from the video platform in order to support our clients?
Yeah. Again, if a vulnerable person needs a break because of focus and concentration issues, so if they're only able to focus for 40 minutes and then they need a break, there's no point then in having a conference with your advocate in that break, because they're not going to be able to take in the information. So the way, as an intermediary, we would often recommend breaks to be managed is that the break is sufficiently long for the person to go out and have their cigarette outside, or however they choose to clear their heads. And then, if needs be, to have some time with their legal representative so that they can instruct and take advice from them. An intermediary, if they felt that there was issues around that and the CVP hearing, may recommend a shorter court day and may recommend longer breaks. And I would say, even if you don't have an intermediary, try and think about the fact that that person will need the decompression time as well as time with you. And if it's possible to ask for that before the hearing and have it all set out so everyone knows what to expect, that would be really helpful. And again, if you have an intermediary, they can simplify the court paperwork that you might need to run through with people, and they can simplify the concepts that have been discussed. So hopefully the meetings that you will have around the remote hearing should be shorter and more focused.
Yes, and I think that's something that we lawyers need to think about more often is what papers are coming to the intermediary. Are they going to have access to the bundle? And are position statements going to go, so that an intermediary can assist in explaining and breaking down the issues of the day, as well as the bigger issues in the case. So that's a really good point. I'd like to consider now the potential difficulties for clients who've been the victims of abuse or otherwise suffered some traumatic event which may be the subject of proceedings. Nicola, can you start us off on this by explaining the significance of trauma in the context of communication?
Yeah, so trauma, a traumatic experience that somebody has lived, if it gets re-triggered in the hearing in any way, it could be in a sensory way, sort of lighting up the right-hand side of the brain, or it could be a word or whatever. Trauma disrupts the main center for language in the brain. And this disruption, it affects the ability of a vulnerable person to give a verbal narrative. So the main expressive language area of the brain, it can stop working, stop functioning, for example, when there's a flashback that's being experienced. And there can be sort of dissociative amnesia, which occurs when a person blocks out certain information when there's been some kind of trauma trigger. And that's usually associated with a stressful or traumatic event, which kind of leaves them unable to remember important information. And of course, what we're about is access to that information and people being able to communicate as they need to. So it's very common for traumatized people to find verbal communication difficult. And sometimes if they experience a traumatic reaction to something which has been triggered in a remote or in a live court hearing, it could lead to a reaction of fight, which can be somebody jumping up and leaving the room, or flight, freeze, so the person can suddenly become quite unable to do anything, or a kind of dissociative reaction whereby they may just suddenly start smiling, or some kind of inappropriate response. And of course, there's the flop reaction that we're knowing more and more about now, where somebody just becomes incredibly acquiescent. You know, it's the body's survival skill that says, stop fighting now. And they'll just basically go along and agree with anything you say. Now, I don't have to say to you how disastrous that is in the court context, particularly if somebody's giving evidence or if they're missing out on chunks of the evidence which is being given by other people. Basically, the alarm center in the brain, the amygdala, rings. It's like a fire alarm. Defense mechanisms come up. And actually, if you can't sort of disarm those defense mechanisms, which is a role for an intermediary again, then you could be stuck. And if that vulnerable person is on their own somewhere, and all these things are playing out, you may not even notice it. You may not even be aware of the fact that they are not there. They might be present, but none of that information is going in. And if they're giving evidence, whole chunks of evidence may simply be blocked out. So that's the real difficulty with trauma and remote hearings. And of course, you as the advocate, how are you going to know? How are you going to be able to tell? A lot of the things that you might use usually just won't be available to you in remote hearings. So I hope that answers the question. That's broadly the impact of trauma in the court context.
No, it really does. Thank you for that. And I just wanted to touch then on how is that affected by the prospect of a vulnerable individual who's been affected by trauma joining a hearing from home in which some of those issues are being touched on, even if they're not giving evidence, but the subject matter may be raised as an issue to be discussed in an interim hearing.
It's totally key, Siân. I mean, the venue is important, full stop. I've helped somebody to give their evidence from a very noisy children's centre that just was very difficult. But if somebody's in their home environment, we as registered intermediaries have had guidance from the police about the fact that asking somebody to relive a traumatic event in their private personal space can then contaminate that safe space and can lead to psychological issues and difficulties for them that will go way beyond the end of the hearing. And if you imagine in lockdown, if that is their safe space and it's contaminated with the events from the hearing, you've actually done somebody a massive disservice way beyond the impact of the court hearing. So it's really key to explore if there is somewhere else that's available in those situations, a different venue, a suitable venue. And if they are going to be wherever they are, would a supporter be necessary? So somebody, as an intermediary, I can't give emotional support. My duty is to the court and that's not my role. So they may well need somebody there just to be able to keep them in the right place, and also, you know, to give them emotional support going through things that are horribly difficult. And of course, if you've got somebody who's had adverse childhood experiences, which is very common, obviously, in the family courts, those trauma triggers could be going off left, right, and centre. And experiences that they've had in the home, you know, it may still be their home environment. To ask somebody to relive that from their home environment is a disaster in terms of the impact on them.
And just thinking about how important it is to have the right emotional support, which is particularly difficult in the remote setup. So not a lawyer, not an intermediary, but someone who's there just for that purpose, is to aid in participation. I think I would instinctively feel that a person who's had a difficult hearing, for example, in interim removal maybe, where they haven't been properly supported, may find their ability to participate in the next hearing, whatever it is, has been adversely affected by that experience. Is that a fair assumption on my part?
Yeah, 100%. I mean, what if you are making somebody experience a traumatic event without the right level of support, without it being placed in the right way, then you are leading into a whole new set of trauma-related responses. So I think that's a really good point to raise, Sean. Very valid.
Is it ever realistic, and you've touched on this, to think that we can keep an eye on someone's emotional state during a telephone or video hearing?
Again, it depends on the person. I've had vulnerable people with mental health conditions who, and you must have had this experience, who would, unless they're guided in some way, would be sending a message on WhatsApp every 10 seconds. And it is possible for the advocate and the vulnerable person in certain situations to maintain contact in that way. But in a lot of cases, you know, it's just simply not possible to notice. An experience I had was working with somebody remotely, and it was only afterwards that they told me that they were crying, and I couldn't even see it. And in another experience, I was with a child in a criminal court matter, and we were on a remote live link. The judge could not see that the child was actually shaking and crying, just couldn't see it. And, you know, it's just the difficulties with this technology, really.
Thank you. We've talked a bit about the setup, and it's a key theme actually in the Nuffield reports is how we approach this. So it seems that the attendance of lawyer, intermediary, supporter, and of course client together in one place, whether that's at court or not, seems to be the most significant step that we can take in terms of improving participation. Is that right? I mean, is that really the sort of remote hearing gold standard?
Yeah, I think that's really well put. I mean, when we were all finding our way originally, I was popping up in places, advocates were somewhere else. And it became clear as we were finding our way that really the best option for the vulnerable person quite often is to have their advocate on site, albeit quite often in a different room, so that the intermediary and the vulnerable person don't interrupt the advocate when they're trying to do their job by talking or, you know, whatever. But also the vulnerable person then has the advocate there, and then they don't have to do another remote piece of work by telephone or on a Zoom link. They can just go into the other room or have 5 minutes. And also, to be honest, I find that a lot of advocates are amazing at supporting their clients, at understanding them. They've sometimes been on the journey with them for a long time. And there's a level of rapport that's been built that is also incredibly useful to a vulnerable person in those circumstances. So, yeah, I would say that that's right. Gold standard is to have advocate, intermediary, and vulnerable person in the same location.
Obviously, we know that can pose a challenge where parties or lawyers are shielding or self-isolating. So it's a difficult issue. And the issue of hybrid hearings, which is the other option, which is a slightly different version of the same event, I suppose, where the vulnerable party and the people, relevant people, will be at court rather than in a separate remote location. And it's often assumed that hybrid hearings are, as I use the term again, the gold standard for a vulnerable party. And I wonder if we need to avoid making assumptions about whether a hybrid hearing is best for someone.
100%, yeah, Sean, I agree with that, because really going back to it's all about the person. You know, some people might manage best in the court environment with an advocate directly asking them questions in situ. Others will manage far better when they're in a safe, closed space with an intermediary, with the advocate next door. Again, the different ways that they have to interact with the technology. In court, you have that screen, all the people are moving around, difficulties there. Some people might feel more control or in control if they're sitting there in a CVP or a Teams meeting, and they've got the ability to switch certain things on or off. So it really depends on the person and what their needs are. And again, it's a matter of a discussion there to work out what will work best for them.
Sorry, I was on mute there, so remote failure. I just wanted to comment on, I think a distinction is often drawn between the way we deal with case management or interim hearings and final hearings, and the focus being on how we manage final hearings. And much has been said in the guidance, including by the President about this, and I won't rehearse it, but I wonder if, as lawyers, we need to think a bit more about the type of hearings that we're treating as interim hearings. We know we can have some really important ones like interim removal. Within the private law sphere, the first two hearings are aimed at trying to resolve the disputes between the parties, and they may be the only hearings that take place in the case. Same is true, I think, for financial proceedings, particularly financial dispute resolution appointments. So I think they're not just administrative hearings, and so the platform and the way that we run them, I think we can safely say requires a lot of thought along the lines that you set out today, Nicola, in light of our evaluation of the importance, I suppose, of the hearing for our clients. So that's just my comment. But the last thing I really want to ask you about is ground rules hearings. I wonder if you can just give us your experience about how they are functioning in your experience remotely, and whether there are any improvements that we need to make from the intermediary position as to how we're conducting those hearings.
Yeah, I think the first question is the ground rules hearing for the first remote hearing, which is something which isn't really taking place. And the fact that sometimes we will get the link for the telephone hearing and nothing has been agreed or discussed. So again, an early ground rules hearing as to how those remote hearings will be managed, I think would be really key. To make sure that everything's in place. In terms of the general ground rules hearing before hearings, again, it really depends on the judge and I suppose how well people work in the remote environment. I find it quite difficult sometimes if an advocate is basically referring to my report and everyone says, yes, that's all agreed. And sometimes a case management order has been written in draft before we've even had the hearing, and there's some distinct points that really need to be drawn out. And I find it quite difficult sometimes to find my voice on a remote hearing, knowing should I intervene or how is that going to work. But other judges have been amazing, really rigorous, really good at outlining every step for the remote participation and how things should work throughout. So variable practice, but I think, as we've said throughout, it's really all in the planning.
Yes, and again, that's something that we can think about as advocates, is planning how you will participate in that hearing, and discussing it with you beforehand, I'm sure, as well, would be really helpful. So thank you for that. I'm going to wrap things up now, but and many of these points may seem, as we go along, to be in some way obvious in terms of how remote hearings should be managed, but the evidence from the Nuffield reports are that the good practice isn't always followed. It's obviously impossible to give a guide that will cover every situation, as we've said, and we're on a steep learning curve so far as the impact of remote hearings is concerned. So the emphasis, I think, must be on concentrating on looking at the issues that are in play and getting the measures in place as early as possible, and then reviewing those measures as the case progresses to see if we've learned a bit more or we have a bit of better understanding about how we're progressing with our clients. Nicola, thank you so much. That's been incredibly helpful, and I'll hand back over to Gemma in just a moment to wrap us up, but I hope that's been a helpful interlude into the remote family court for everyone.
Been extremely helpful. Thank you so much, Siân and Nicola. I've just got two questions very quickly before we do wrap up, because it's been so fascinating. but we mustn't be too much longer. Firstly, Nicola, with respect to ground rules hearings, I certainly picked up from the incredible FLBA training how far behind we are in the family system as compared to the criminal system with respect to really properly honing down the issues at ground rules hearings. And I just wondered if you wanted to comment on that, because I know we all go through the motions of this is what the intermediary report says, tick, this is what we have to do, but we never, or it's never been my experience, that the court really hones down the issues that a witness should be questioned about, how many questions should be put, etc. I don't necessarily want a yes or no answer, but do you agree that there's much more that we should be doing?
Yes, I do, Gemma. I mean, obviously working in the criminal courts as well, the judge is a lot more proactive quite often, and they will look at things that the intermediary can't look at. Like you say, the length of questioning, whether certain questions are appropriate or not. And it's very difficult sometimes as an intermediary, you look at questions and obviously you're just looking at communication. But some questions you think, well, I've seen this in the evidence. It's not for me. It's not a matter for me. But again, a certain amount of proactivity within the family courts, I think, would be really welcome.
So we must be reminded to look at what's really relevant. I think we all have to learn together. And the other burning question I had, which is a question that comes up again and again, and it's the issue of remote intermediary assessments, and can they ever be appropriate? It's chicken and egg, I know, but it's extremely difficult. So just some words of advice, please.
Absolutely. I know at the start of lockdown, Communicorp were not doing any remote assessments, but I think our understanding and knowledge has developed. At Intermediaries for Justice, we've held trainings on remote assessment and remote working, and we've contributed and drawn together and found out the areas where it is possible to do a remote assessment for certain classifications of vulnerability. That said, I always say I have to follow up with a face-to-face because, as I said at the beginning, there may be some things which are specific to the remote communication, and until you see the person, you wouldn't know that. But yeah, in these difficult times, we're all having to adapt and do what we can. And if I've tried to do an assessment with a vulnerable person, sometimes I don't even get past the initial phone call, and then I say, well, it's not going to be possible. I might just be able to do some very focused bits of work and say the rest I'll complete when I can. So better than no assessment at all, can work for some people, is completely out for others.
Thank you so much. I think we're going to wrap it up completely now. Thank you to Siân and Nicola. I hope this has been recorded so that if anyone missed any of it or came late, you have the pleasure of seeing us all on Zoom, sorry, on YouTube. Please stay tuned for our next webinar, which is on the 9th of February. It's FII for beginners, in brackets for idiots. Like myself, which is going to be presented by Tina Cook QC and Sharon Bachu. Otherwise, all I want to say is thank you so much again to Siân and Nicola, and thank you all for watching. Good evening.
Thank you.